Good morning. We'll ask people to take their seats so we can begin. Quiet very quickly. Let me welcome everybody. Thank you so much for being here on a Thursday morning. And I'm delighted to have so many of you come out for this breakfast. Let me bring up our Dean and President, Anthony Crowell.
Thanks so much, Ross. It is nice to welcome you all here today. Thanks for being here. I'm Anthony Crowell, the Dean and President at New York Law School, and we have an extraordinary program today featuring the Department of Investigation Commissioner, Jocelyn Strauber. We are New York's law school. For 133 years, we've always felt a very special obligation to engage on the key legal and policy matters that affect our city, and of course, to serve as a resource and partner to government in so many ways. It's nice that many of our students are here and certainly many of our graduates. And I will say that fighting crime is one of the key aspects of what we like to help our students learn about and to ensure that they are going to be the most effective they can be on the front lines of public service. And I'm pleased to see that a number of the students here today will be working in summer positions doing just that. I want to just mention that 1/3 of our graduates enter public service each year. And most recently this year, we had the second highest number of placements nationally just before Georgetown Law Center in public service jobs. It's a nice achievement for our school and a testament to the kinds of efforts that we take to ensure the highest quality instruction and sets of opportunities. And all of that is embodied in the kind of work that Ross Sandler has done for 30 years as the director, and I should say the founder and director of the Center for New York City Law. And of course, Alice Sandler, who has been by his side and is always a mainstay at these breakfasts, helping to host them. One of the nice things about our relationship with DOI is that it's not only longstanding, but a number of DOI staff and former staff are part of our community. I'm proud to say that General Counsel and Deputy Commissioner for Legal Affairs at DOI, Andrew Brunsden, is one of our top adjunct professors, teaching a number of courses and doing it with such energy and enthusiasm and great love for our students. And in return, he is highly valued by them. And certainly Michael Siller, the former General Counsel and Deputy Commissioner at DOI, who is now our Chief Compliance Officer and Counsel. So we are well served by DOI current and former execs. And I like to always mention, and I'm proud to mention that we have the former Deputy Executive IG from the MTA, Pepe Cheng de Castro, who is currently the Deputy Counsel to the Governor, who is somebody who was a fellow at the Center for New York City Law, and I want to just recognize her. Thank you for being here, Pepe. It's great to see you. I will quickly mention, as I feel compelled to do at every opportunity when we talk about public integrity, that we are also responsible for creating a permanent employment position for ethics attorneys in municipal government because Jimmy Walker is one of our graduates. A very colorful alum who served our city early in the 20th century. And I think he is a good reminder of why we do what we do. Sometimes you have alums who make you really proud, and sometimes you have alums who you can point to as reminders of what not to do. In any event, I just want to thank the Center for New York City Law staff. We obviously have a great deal of appreciation for Ross, but beyond Ross, we have our program director and executive editor, Ben Max, distinguished fellow and counsel, Steve Lewis, who recently left city government to join NYLS. We have senior fellow and director of the Census and Redistricting Institute, Jeff Weiss, our city land editor, Veronica Rose, and of course, our city law administrative coordinator, Rose White. Now, without any further ado, I will hand the podium back over to Ross, and we look forward to Commissioner Strauber's remarks. Ross?
Thank you so much, Dean Crowell. Let me first, I want to thank our founding sponsors and long-term sponsors, Greenberg Traurig, thank you for being here, Consolidated Edison and Verizon. I also want to thank all of you for being here. And for many of you who voluntarily contributed, you have a little gold star on your nameplate. Thank you for contributing and making these breakfasts possible. I also want to, you mentioned former fellow, I should also mention Sheila Oresti, who also worked at DOI and was the first fellow at the Center for New York City Law, who's also here. Thank you all. Today we welcome DOI Commissioner Jocelyn Strauber to the CityLaw Breakfast. She was born in New York City, graduated from Brearley here in Manhattan, Brown University, where she was magna cum laude, majored in English, on to Duke Law School, where academic achievements were equally high, managing editor of the Duke Law Review, from then on to clerkships on the Circuit Court for the District of Columbia, and then for the Supreme Court for Justice William Rehnquist. She worked for 8 years at the Southern District, my old place of work, and rose, she was there for 8 years, rose to be co-chief of the Terrorism and International Narcotics Unit, something we didn't have back when I was there. More recently, she was partner at Skadden Arps just before becoming Commissioner of Department of Investigation. The Department of Investigation, which she now heads, has a unique place in city government. Its uniqueness can be traced back to 1873 and the scandals involving Boss Tweed and Tammany Hall. The scandals involve graft and theft, of course, but also mismanagement of city resources. And the graft and corruption was revealed by the reformers who then took over city government. And as a result, in 1873, they created the forerunner of the Department of Investigation and gave it its unique charter. DOI is both a mayoral agency responsible to the mayor and also at the same time an independent investigator of both civil mismanagement and criminal conduct. It can investigate civil or criminal fraud, waste, abuse of authority, criminal wrongdoing by city employees, contractors, business associates, benefit receivers, anything the city does and anywhere in the world. This dual nature of DOI as a mayoral agency and a criminal investigator was highlighted in the 1960 volume Governing New York City by Sayre and Kaufman, the classic on city government. In that volume, in language that's really memorable, Sayre and Kaufman wrote, "The Commissioner of Investigation holds an office of unpredictable consequences for its incumbents. The opportunities for prominence have been somewhat overshadowed in the history of the department by the chances of obscurity. The uncertainties of the office arise out of the anomalies and the ambiguities of its assignment in government. Is the Commissioner of Investigation the investigator for the mayor, only protecting and doing the bidding of the mayor, or is the Commissioner the institutionalized public conscience, taking the department's investigations wherever conscience leads?" The answer, of course, is both. The commissioner does and must respond to both of these charter imperatives. Commissioner Strauber, with her exceptional academic background and extensive investigative and prosecutorial experience, has shown that she is capable of meeting both of those imperatives of her office. New York Law School is pleased to welcome DOI Commissioner Jocelyn Strauber to the City Law podium.
Good morning, and thank you, Dean Crowell and Professor Sandler, for that lovely introduction. I think I'm going to go with the conscience of the city and the institution rather than the protector of the mayor or any other city official, but I'll get into that a little bit more in a moment. It's an honor to be here today. It's wonderful to look around the room and see so many current DOI colleagues, as well as former DOI team members, other members of city government, the agencies that we work with, as well as some of the attorneys that we have an opportunity to interact with in the work that we do. As Dean Crowell has already said, this institution really has a unique relationship to city government service, and I'm speaking about New York Law School, that is, through the courses that you offer and the many current and former city officials who work and teach here. And as the dean has already mentioned, that includes our Deputy Commissioner and General Counsel, Andrew Brunsden, who's here this morning, and many other members of our executive staff, supervisors of our investigative squads, and the attorneys that counsel them and conduct their own investigations, and many of them are here today as well. I have served as DOI Commissioner since February of 2022. And while this is my first time in city government, it is for me a welcome return to public service, and I'm grateful to have been given the opportunity to have a positive impact on this city that I love so much, where I was born and raised, and have lived nearly my entire life. My husband and I count among our greatest accomplishments that our two children, one in high school and one in college, are diehard New Yorkers. In my professional life, as Professor Sandler mentioned in his introduction, I've moved between public service and private practice, from law enforcement to defending clients facing government investigations, and now back again. And I would like to say that I planned this path and that I knew that a legal education would provide a foundation for meaningful engagement in the public and private sectors. But the truth is that I really lucked into it. I had a good role model for a fulfilling legal career in New York City. My father, who has practiced litigation here for over 60 years and counting, and as a college English major, law school seemed like a natural continuation of my liberal arts education. I realized in my first year of law school that I had a deep interest in criminal law, and in particular, a curiosity about those who don't play by the rules and why they don't, and what we as a society can do about that. Early on in my career, I found that I had a love for the investigative process, for finding facts, reconstructing past events in a careful and thoughtful way, and to come as close as possible to determining what occurred and in what context. A passion for that work has been the common thread throughout my career, and it has provided me with a variety of opportunities to make a contribution, and I hope to make a difference. While I found challenging work and wonderful colleagues and clients in private practice as a criminal defense lawyer, it has been my experience, and I think I am not unique in this, that public service provides unparalleled opportunities for attorneys to do important and meaningful work that positively impacts their communities and beyond. And that is because the guiding principle in public service is to do the right thing for the right reasons every day. As some of you may know, that is the ethic of the U.S. Attorney's Office for the Southern District of New York, where I was a prosecutor for over 8 years. That office really shaped how I think about the investigative process and the practice of law, and set a standard that I strive to meet and to uphold to this day. And one of the key lessons for me was that to uphold that standard, to do the right thing, you must be fair, you must be independent, and you must be guided entirely by the facts and the law. And to do that, you must be rigorous in your assessment of information that you think you know, questioning what you might be missing, and looking at a situation from all sides. You must test not only your theories, but your assumptions and your biases, of which you may not even be fully aware. Without that rigor, you cannot seek the truth and you cannot pursue justice. I think this measured approach is particularly important in law enforcement, where the conclusions we reach and the cases that we bring have a profound and immediate impact on people's lives. We must guard against a drive to reach any particular outcome, which can lead investigators to dismiss evidence at odds with their initial suspicions, rather than to follow the evidence where it leads. Law enforcement does not always get it right, even with the best of intentions. I learned that as a prosecutor, and I also saw that as a defense attorney, both very early in my career and more recently in the 8 years I spent in private practice before coming to DOI. These lessons guide me every day in our criminal investigations where liberty is at stake, in the reports where we make and publicize findings about the conduct of city officials and agencies and the parties who contract with them, and in publicly issued recommendations where we propose that agencies implement reforms. Today, I want to speak with you about DOI's anti-corruption mission and how we approach our work, share a brief history of the agency, which Professor Sandler has already alluded to, and then give some examples of our investigations and our policy and procedural recommendations that I hope will illustrate the important contribution that we make to the city. DOI is unique among law enforcement and oversight institutions in two ways: the breadth of our oversight and our statutory protected independence. I'll say more about this in a moment, but I want to be clear at the outset that independence is not isolation. First, our mandate and jurisdiction are extremely broad. The New York City Charter authorizes the DOI commissioner, among other responsibilities, to make any study or investigation which, in her opinion, may be in the best interest of the city, including but not limited to investigations of the affairs, functions, accounts, methods, personnel, or efficiency of any agency. This staggeringly broad mandate and the deep expertise of the career inspectors general and their teams give DOI the authority and the obligation to hold public officials accountable, to improve city government, to protect its resources, to improve agency practices and operations for the benefit of all New Yorkers, and in particular, I think, those who are dependent on city government for day-to-day services and support. And in doing that work as a city government institution, we make clear to the public that their city government values integrity, transparency, and efficiency. That is to say, the core features of good government. I want to be clear that good government requires, and it is DOI's obligation to pursue, accountability of public officials at every level, because no one is above the law. As many of you are no doubt aware, DOI is currently involved in investigations of senior city officials and employees, the kinds of investigations we have always done throughout our history. For obvious reasons, I won't discuss the details of those inquiries today, but I want to be clear that those investigations are among our most important responsibilities. Second, while a mayoral agency that is part of city government, DOI also is simultaneously independent of city government. That independence is critical to our ability to fulfill our mandate, and it is protected not only by existing norms, but by city law. For example, the DOI commissioner must be confirmed by the city council and can be removed only with a public statement of reasons by the mayor, to which the commissioner can respond. In addition to its subpoena power, DOI is authorized by statute to obtain any city records, documents, or other information for use in its investigations, and can compel interviews of city employees and some city vendors. Other than formal referrals for investigation, which may be made by the mayor and the city council, and which are relatively rare, our investigative priorities are set by our agency, by our executive staff and career inspectors general, and not by City Hall. I do not report on interim findings or other developments in DOI investigations, whether administrative or criminal, to City Hall or the relevant agencies. DOI responds to press inquiries and speaks to the public about our work without the review or approval of anyone else in city government. But as I noted, DOI is not and should not be an island in order to provide effective independent oversight. And by that I mean we should not, as a general matter, be inaccessible to or unwilling to engage with the agencies that we oversee or with senior staff at City Hall. Rather, our oversight functions best when we have a collaborative approach with agency leadership, who know their agencies best and can be well-positioned to flag risk areas for DOI's review, and when our colleagues at city agencies share our goals of integrity, efficiency, and transparency. Of course, if an agency doesn't share those goals or is a target of an investigation at senior levels, we will adjust the level of collaboration accordingly. And in all events, collaboration does not mean surrendering our independent judgment and decision-making with respect to our findings or the content of our reports and recommendations. It does mean providing the relevant agencies the opportunity to review final reports and recommendations before they are issued, for awareness of the issues that we have identified, and to provide feedback. It means that we seriously consider that feedback and City Hall feedback, if any, particularly as to the accuracy of factual information we have included about agency operations and as to the feasibility of our recommendations. But whether and how to incorporate that feedback in the reports and recommendations that we issue is solely DOI's decision. Collaboration with our prosecutorial and other law enforcement partners also is a key component of DOI's approach. When we conduct investigations that may involve criminal conduct, we reach out to the appropriate prosecutor's office early and often, and we will work together as full partners on the investigation. We do this to ensure that the evidence we gather will be admissible as a matter of law, and also because in our experience, the strongest cases from a factual perspective are built with the input of the prosecutors who will ultimately charge and try them. Collaboration, therefore, ensures that we are using our limited investigative resources efficiently. And our input is critical to cases involving city officials and employees because of our unique perspective and knowledge of city government, as well as our statutorily mandated access to documents. When we conduct criminal investigations, grand jury and other confidentiality restrictions generally prevent us from sharing information with the relevant agency as the investigation proceeds. But if we learn of public safety issues or risks to city resources or other issues that in our view require urgent attention, we will work with our law enforcement partners to determine what information can be shared so that agencies can protect public safety and limit those risks while maintaining the confidentiality of the investigation. Finally, as a city agency with a broad mandate to improve city government, DOI has an obligation to do more than investigate cases and pursue criminal charges where warranted. Oversight functions best when it is comprehensive, meaning that DOI not only pursues criminal charges or administrative discipline against specific wrongdoers, but also makes policy and procedural recommendations to the relevant agency or agencies to reduce the risk that such wrongdoing will reoccur or go unnoticed, and then follows through with the relevant agency to press for implementation of those policy or procedural changes. We make those recommendations in formal written referrals, but also in less formal communications with agencies that occur in real time, depending on the nature of the issue. Where the alleged wrongdoing and the recommendations are of great public interest or have widespread impact, DOI may also issue a public report that provides more details about the investigation and the recommendations that we have made. Our other responsibilities, including serving as an investigatory arm of the city's Conflict of Interest Board, conducting background investigations of candidates for certain city positions, and supervising integrity monitorships of city vendors and large-scale city projects, are also important components of our oversight mission. In all these ways, DOI promotes and supports good government in New York City. To say a bit more about our history, and as some of you may know, DOI was founded in 1873 in the wake of the massive corruption scandal of William Boss Tweed, who with other city officials engaged in a kickback scheme that cost the city billions in today's dollars. Tweed and others controlled access to city contracts for massive projects, such as the downtown Tweed Courthouse, which is right nearby, and they demanded and received bribes from city vendors in exchange for awarding those contracts. The bribes drove up the cost of those projects to the city and called for two sets of books, one reflecting the public cost of the projects and one reflecting their true cost and the bribe payments. When a city employee from the comptroller's office exposed Tweed's misconduct by sharing those records with several newspapers, the resulting public outrage led to the creation of an independent agency empowered to investigate corruption anywhere in city government. In 1873, that agency, the precursor to DOI, was called the Office of the Commissioners of Accounts. The new department was given subpoena power and the power to take testimony under oath. As its early name suggests, the commissioners and their staff of 7 were intended to ensure that the city kept accurate financial statements as a means to prevent fraud. Over the years, DOI's legal authorities and headcount expanded, but its fundamental mission to prevent fraud and abuse endures. Today's DOI is an agency of inspectors general, investigators, attorneys, auditors, data and policy analysts, digital forensic experts, information technology experts, and a full administrative staff. We are made up of 10 units, each headed by 1 or 2 inspectors general. Each unit oversees specific agencies, generally grouped by function, such as the Department of Correction and Probation, the agencies that handle city buildings and housing, agencies with uniformed personnel, such as the fire and sanitation departments. We have a unit dedicated to the operations, policies, and programs of the New York City Police Department, and a vendor integrity unit that oversees our integrity monitorship program. To this day, the media plays and continues to play an important role in uncovering potential corruption and raising legitimate concerns about how the city operates. DOI, of course, closely monitors that reporting, and it often informs our investigations. And we strive to be as transparent as possible with the public about our work while maintaining the confidentiality of the ongoing investigations that we do. We open investigations from a variety of sources, complaints that come in from members of the public as well as employees of city agencies. They come into our inspector general offices. They come from other law enforcement officers. And as I said, they come from media reports. In 2023, we received more than 14,000 complaints. We also conduct proactive investigations, including through the use and analysis of city data to identify red flags that may indicate fraud or abuse. As I explained, our approach is comprehensive, meaning that our investigations often result not only in criminal charges and administrative discipline, but also in policy and procedural recommendations to reform the functions of city agencies. Our recommendations can have particular force when they are announced simultaneously with a criminal prosecution. Although we are in a constant dialogue with the agencies that we oversee, and we don't wait until such announcements to identify areas where change is needed. But the reality is that criminal charges, as well as in-depth public reports, generate attention and can prompt policy change that an agency might not otherwise prioritize. Ultimately, whether or not to implement DOI's recommendations is an agency's decision, and the agency, and by extension, City Hall, must balance our proposals and the resources they require against the agency's other priorities. City agencies may decline to accept our recommendations, but that choice may leave corruption risks unchecked. The announcement of the arrests of 70 current and former employees of the New York City Housing Authority on bribery and extortion charges by the U.S. Attorney's Office for the Southern District of New York, and DOI's simultaneous issuance of 14 recommendations to NYCHA for reform in February of this year, is one example of the success of our comprehensive approach. The defendants were charged with allegedly accepting cash payments from contractors in exchange for awarding NYCHA contracts. The conduct alleged was widespread, touching every borough of New York City and nearly 1/3 of NYCHA's 335 housing developments. As charged, the defendants exploited the no-bid process for goods and services under $10,000, commonly referred to as micro-purchases. That no-bid process, handled at the housing development level, was intended to ensure swift completion of necessary lower-cost construction and maintenance work in those developments. But instead, the charge conduct drove up the cost of this kind of work and diverted valuable public funds away from public housing and into the pockets of corrupt NYCHA staff. DOI's 14 recommendations focused on the reform of the micro-purchase process to protect it from abuse, and NYCHA agreed to implement all of them. Now, DOI had made several of the recommendations in 2021, following 3 bribery prosecutions also involving NYCHA procurement, and NYCHA had not accepted them at that time. In particular, DOI had recommended that the micro-purchasing authority be removed from the housing development level and transferred to specialized, centralized staff with the necessary expertise. NYCHA rejected those recommendations in favor of other changes they implemented intended to reduce the risk of bribery but maintain the original purchasing structure. DOI's recommendation called for a significant shift in that structure, which in NYCH's view at that time would delay the repair and construction process. Now, we could not have known in 2021 that 3 years later, our investigations would lead to the largest single number of bribery arrests in the history of the U.S. Department of Justice. But our recommendations back in 2021, based on our extensive experience, represented our best judgment about the necessary and most efficient ways to reduce the risk of corruption. And this case provides a clear illustration of the dangers of declining to implement those recommendations. Another recent criminal investigation that we conducted with the Manhattan DA's office, with the assistance of the Department of Buildings, resulted in the indictment of a construction safety training school on charges that it sold fraudulent safety certifications without providing the required training, as well as charges against brokers who allegedly conspired with the school to obtain these sham certifications. Together, these over 20 defendants allegedly facilitated evasion of New York City's construction safety training requirements, which are intended to protect workers and all New Yorkers in proximity to construction sites. As charged, a construction worker purportedly trained by the school, including with respect to fall protection, but who in fact did not receive safety training, was killed when he fell from the 15th floor of a building under construction. The investigation revealed several ways in which the Department of Buildings could improve its oversight of these safety training schools. And DOI made policy and procedural recommendations to DOB in connection with the announcement of the charges in this case. Some of those recommendations will require legislative and regulatory changes to increase DOB's authority over safety training schools. And DOI recommended that DOB seek those changes. DOI also recommended other enhancements to DOB's training compliance unit and its procedures, which included the hiring of additional personnel. DOB recognized the value of these recommendations and agreed to implement all of them, with the caveat that some will require additional budgetary support. DOI also issues public reports on a wide variety of matters that may not involve criminal conduct, but have citywide relevance or are otherwise of significant public interest. Reports can inform the public about matters that may not be fully understood, offer a window into DOI's investigative findings, and explain the basis for our recommendations. Like criminal cases, DOI's public reports can generate media interest, and the existence of a public report can incentivize agencies to accept our recommendations. Beginning several years before I arrived at DOI, our Office of the Inspector General for the New York City Police Department undertook an examination of the New York City Police Department's criminal gang database, a repository of information concerning individuals that the NYPD believed to be gang affiliated. That investigation was prompted by significant public concern about the nature, use, and implications of being included in a database identifying individuals as gang affiliated. Community and advocacy groups called for the database to be abolished by local legislation, asserting harm to individuals who were labeled, often incorrectly, as gang affiliated. The NYPD defended the database as a necessary law enforcement tool, noting, among other things, that the database had been substantially reduced in size and subject to other changes since DOI's investigation began in 2018. The 2023 DOI Gang Database Report, consistent with the practices I have discussed, stuck closely to the facts found in our investigation. First, we were able to provide the public with detailed demographic information about the individuals included in the database, NYPD's policies for determining whom to include, and the documentation of and periodic review of the individuals included in the database to determine whether inclusion remained warranted. We also looked at NYPD's policies and described in the report the policies for determining whom to include and the documentation of and periodic review of those determinations. Second, we conducted an in-depth analysis of 1,200 documents that purported to support 500 individuals' inclusion in the database. And we found that NYPD failed to provide sufficient guidance about the criteria for including an individual in the database, and that in some cases, NYPD did not follow its own procedural requirements and did not maintain adequate documentation supporting those inclusion decisions. We also considered the claims of legal advocates that being included in the database had significant negative impacts on their clients, as well as media reports and other claims made of harm suffered. Because we were not able to substantiate that the harm those individuals suffered flowed from their inclusion in the database, we were unable to identify a relationship between inclusion and individual adverse outcomes. Our report acknowledged, however, that harm may not be readily determined in this context, and that the existence of the database did cause fear in certain communities and thereby decreased public confidence in the NYPD and strained police and community relations. Based on our findings, we recommended 17 reforms to NYPD's practices relating to the database, but we did not recommend that it be abolished. We proposed strengthening written policies and regulations surrounding the inclusion, renewal, and removal of individuals from the database, a review of each entry to confirm that inclusion remains warranted, and the establishment of policies specific to the inclusion of minors in the database, including parental notification. Advocacy groups with whom we met after we issued the report expressed frustration and disappointment with many of our findings and conclusions. The NYPD accepted 11 of our 17 recommendations, rejecting 5 and keeping 1 under consideration. It is often the case that when we complete an investigation of significant public interest, the relevant agency asserts that some of our recommendations are unreasonable or go beyond what is necessary, while other stakeholders claim that we have not gone far enough. And that's fine. Indeed, those recommendations may be those reactions may be indicators that we've done exactly what we should. Because as I've made clear, our only job is to find the facts in a fair and rigorous way and to use our best judgment to determine the policy and procedural changes, if any, that the facts support. I thank you for the opportunity to speak with you today about the importance of the work that we do at DOI. I think it is fair to say that we are in unprecedented and unnerving times in our city, our country, and the world. There is a lack of trust in government, fueled by deep division on fundamental issues, a notable absence of civility in public discourse, and an unwillingness to grapple honestly with the facts. I am therefore particularly grateful to be in this role at this time and to work with our career inspectors general and their teams to conduct objective, fair, and rigorous investigations that follow the facts and that ultimately seek to hold public officials and employees, as well as institutions, accountable, to protect public resources, and to propose improvements to policy and procedure that promote good government. DOI has the independence and the authority necessary to do this work effectively, and we have only one agenda: to improve city government so that it can better serve all New Yorkers. Thank you.
Thank you so much. And now we're going to have questions and answers, as we always do. We have 20 minutes. We'll start on this side over here with Joe Jaffe, and then we'll come over here. People, we'd like you to line up so we can ask the questions and comments. You had comments as well. So please go to the microphones.
Commissioner, good morning. Thank you for that presentation. Given the breadth of the mandate that the DOI has, and given the economic status of the city and everything impinging, I have a 2.5-part question. What criteria are you using to allocate the limited resources you have over the broad range of topics you have to deal with? And is that being influenced by the current administration? That's the first 1.5. And the second question is, what criteria are there? What are you using to decide when and with what speed reports that are produced are made public and broadcast?
Okay. Thank you for that question. So let me take the first part, which I think is how are we identifying criteria for selecting and pursuing investigations? And does the current administration play a role in that decision? So let me answer the second question first. The current administration, in terms of its input, plays no role in how we determine the criteria to use to accept investigations, to pursue investigations, except that there is the city charter allows the mayor to refer to us matters for investigation. That's happened once in my tenure involving a security company, and that happened, I would say, early on, probably in 2022. So that's a rare thing. Other than that, City Hall has no influence, and indeed, I do not have discussions with them. I have never had a discussion with anyone, at City Hall about how we select cases or how we prioritize. We do issue stats. We generate stats every quarter that reflect the number of investigations we have, criminal referrals, administrative referrals, number of reports, number of PPRs, so policy and procedural recommendations. City Hall sees those. I've never had a phone call or a conversation about, why are these numbers here or there? So that's the answer to that question. I want to be very clear about that. In terms of how we prioritize, look, we're looking for high impact investigations. So what are those? Those are investigations that might involve fraud of a significant amount of city funds. Those would generally be outside contractor type cases. Clearly, any case that involves, a senior level official or employee is going to be viewed as a more significant priority than one involving lower level employees, I think for obvious reasons. The challenge is that it's not always clear when a complaint comes in, is it going to be something huge or is it going to be something small? And it's before my time, but the City Time case, which was one of the biggest investigations that DOI ever did, started as a relatively small matter. And sometimes when you press on small things, you don't know where they're going to take you. And so we rely very much on the judgment of our inspectors general who know their agencies best, and we're organized in squads by agencies. So they're sort of the first line for vetting our complaints. And I would say and we try not to have, rigid criteria because we don't want to reject something out of hand. So I think what we're really looking for are things that we think could have a significant impact. And, that really is in part by dollar value. As I said, it's in part by seniority. And then there are also, and you can see sort of how this happens, there are certain issues that become of public interest. I mean, the gang database was one such issue. That's an important issue in itself, but through the advocacy community, through media reports, it became something that clearly was important to the public. So, things can, what's of interest in the media can change from day to day. We're not entirely beholden to that, but it is something that we pay attention to. And so if something is an issue of public concern, then that's something that we want to look at. And I have to say, so far, although we may not always go as deep as we would like to because of our resource issues on certain matters, and obviously you don't know what you don't know, we don't categorically sort of dismiss or reject or stop doing any group of cases or investigations. And we haven't had to do that, thankfully, despite the budget environment. I think I got both parts.
Josie, thank you. Just one thing. It's been 24 years since I left the Manhattan Center under Robert Morgenthau, Professor Freddy Krueger. The corruption upon employees didn't return my money and property to me. I can't retrieve my property, but I can sure as hell retrieve my money. I'd like you to help me get the money and give you my contact information later today. But
Okay.
I want either amount I had on March 1 or 2, 2000 times 24 for the obvious reason. I
Okay,
want
well,
extra money for interest.
Thank you. If you have an issue we should know about, we can connect about that afterward.
Thank you.
Thank you.
Yes, I'm Michael Myers, President of the New York Civil Rights Coalition. Your comments about that gang database are very interesting. I am surprised about it. I've never heard of it. I suspect the Civil Liberties Union and other civil rights groups would be appalled that NYPD will be keeping a gang database. And despite what you say about all the points that you raised and the points that NYPD resented and objected to and didn't go with, where is the mayor on this stuff? Where is the mayor? Where is the ethics commission? Where is all the other city conflict boards? Where's the other agencies that are supposed to be riding herd on NYPD? And has the Civil Liberties Union taken any litigation action against this so-called gang database? I mean, the gang database you ought to have is the NYPD gang. Read the New York Post, read the New York Times. The NYPD gang that violate civil liberties and violate ethics of the NYPD, including its police deputy chief, whatever his name is.
Thank you.
You want to comment on that? Yeah. Where's the
Um,
mayor?
Where is the mayor on that? So I think that's a question for City Hall. I mean, the work that we do is to take a look at these issues, to educate the public about those issues. People may disagree with where we come out. You may, others may, that's okay. But what we do is we put the facts out there. But I can't tell you where City Hall is on that beyond the work that we've done and the police department's response, which, as I said, was mixed, but they did accept a number of our recommendations. And I don't think there has been litigation over the use of the gang database. I don't think it is unconstitutional or illegal, but that's always an option that legal advocates have. Thank you. Claude.
Good morning. My name is Claude Millman of Castellanets LLP. The information that you were describing about the Housing Authority non-competitive micro purchases was interesting to me. I was wondering whether DOI thinks about that more broadly in terms of, going beyond NYCHA, since there are other agencies, obviously, that have small non-competitive purchases. And when you're doing that, to me, the danger or a danger would be the importance of non-competitive small purchases in the context of minority and women-owned business contracts, since in those fields you're not dealing with small dollars, but the cap for those kinds of procurements is at 1.5 million. And so I was wondering if the same kinds of recommendations for Housing Authority are applicable more broadly, including that, and if so, how do you do that without interfering with the policy initiatives of the city?
Yeah, no, that's a great question. Well, to be clear, we are not suggesting that there shouldn't be a micro purchase process. I think it is a critical process for ensuring that that procurement can be done swiftly when necessary. And I mentioned that one of the concerns with some of the reforms that we did propose, at least a number of years ago, was that there might be a delay in getting that work done for the folks who are living in NYCHA housing. So I think you do have to balance those concerns when you're thinking about these reforms. What we were saying is that micro purchasing shouldn't be done at the housing development level, where we had seen an overly, close connection between the folks who were getting the work and the folks who were handing it out. And our thinking was, if you lift the authority to a higher level that's more separate from the housing developments, it'll be easier to control it with the recommendations of additional controls that we recommended, and you'll sort of take it out of the zone where we've seen problems in the past. That doesn't mean, though, that you wouldn't have a micro purchase process, and it is certainly significant for MWBs and other contractors and for getting the work done. In terms of citywide application, I would say absolutely it is something that we are thinking about. This, I think, is a good example of, we have to balance in terms of how we spend our time what we're dealing with in terms of conduct that we're seeing that's problematic in a particular agency, and the possibility of going out and doing more proactive work citywide. And so to make recommendations about citywide micro purchase processes, we would need to know more. And that would mean we would need to go out proactively and start looking at agencies where at the moment we may not have any reason to think there's a problem, except for, the logical statement that you make, which is like, well, if it's a problem in agency A, it might be a problem in agency B. And I think that's an example of where if we had, more resources, we might be able to say, let's set up, a team to look at how this works across the city. And it's something we would like to do, and it is certainly something we're thinking about. Whether we're going to be able to do it, we'll have to see. But we are always mindful that when we see an issue in one agency, it may have broader application. The flip side to that is every agency operates slightly differently. And if you make recommendations, and sometimes we do this where we'll issue a recommendation to one agency and then we'll make it citywide, you've got to be sure that it really fits with each agency, or it's going to kind of just fall on deaf ears because it's not really applicable. So I think that's the challenge there.
Thank you.
Hi, good morning. My name's Denise Mira. I'm with the New York City Law Department. Longtime listener, first time caller. So I have a question shifting gears. How has social media impacted your work in terms of how you've seen the impact, perhaps like in investigations or just overall, modus operandi, if you will?
Sure. I mean, I think you could answer that question in a lot of ways. First time caller. Thank you. First, social media has an evidentiary value. And so there are witnesses who may have social media accounts, and you now have another source of evidence, to look at. There are cases where, we've done sick leave abuse cases where somebody might be putting in for sick leave at their agency. And on social media, you can see that, they're hosting a volleyball tournament in their backyard. So it's a source of evidence. And I think that, so that's something we look at. It's also, I think, a source of caution. We want to make sure that all of our folks are now, careful about their social media, that they're not speaking about confidential issues relating to our cases or saying anything else that might compromise them as witnesses, right? So much as we can use it affirmatively, it can also be used in a way to undermine, law enforcement officers if there's information on their social media that's problematic. We use it as an institution to sort of get the word out about our cases. There are things you can do on Instagram with videos and audio that I think can make our cases more real to people and raise awareness in a way that sort of the cold paper text doesn't always do. So we use it that way. And obviously, as has been, in the news a lot recently, what public officials do and say on social media can bring them under scrutiny. And so there are investigations that can arise from that as well. So I think it's had a significant impact, largely positive, but whether it's positive or not, it's here. So, we have to make use of it as we do and deal with it affirmatively and defensively as we do.
Thank you.
I don't like to have this as a colloquy, but I'll ask the questions and no one else. As a former commissioner, I can tell you that I relied on enormously our Inspector General. Very important person to our commissioner. How do you select them? How do you supervise them? What do you think about Inspector Generals at agencies?
So, obviously our Inspector Generals are all our in-house DOI employees. Sorry. Is that better? So our Inspector Generals are all in-house, right? In the sense that when DOI was originally created, IGs used to sit in their individual agencies, and they had sort of a supervisory line to their commissioner, but a dotted line to the DOI commissioner. All of the inspectors general in the city report up through our chain to the DOI commissioner. They are extraordinarily important. I do rely on them. Many of them are here today. I think they set the tone for their squads. They have obviously significant input into hiring their own people. Their agency relationships are critical, and the cases that we bring and the work that we're able to do is enormously enhanced when there is a collaboration, as I said, between the agency and the Inspector General, as opposed to a more arm's length relationship, because often the people on the inside are your best source of leads for investigations. And when they trust you, and when they themselves are good people who are interested in keeping their agency functioning well, you can get a lot of very useful information. In terms of what we look for, I mean, you're looking for folks who are mature, who have experience, who are team players, who have, you know, I think a real passion for this work. That's one of the things, you know, there's a level of excitement and interest that our senior folks have that I think is really infectious. That's how they are raising sort of the next generation of investigators. So certainly the folks that we hire are one of the most important things that we do.
Any other, no, I don't see anybody else standing, so we will bring this to conclusion. I want to thank you so much for an excellent talk and description of all that you do with the DOI. It's such an important agency. We rely on it enormously. And and the choice between being the mayor's person or a conscience, you make the right choice. You have to be the conscience. Sometimes you have to talk to the mayor too. I recommend Ed Koch's book, Mayor, about a discussion he had with his DOI commissioner where he didn't take the advice of the commissioner and got in a lot of trouble as a result. You have to be in the mayor's office and you have to give advice, and hopefully the mayor will take it. As we always do, we like to give a product of the scholarship of this law school to our speakers. This is the wonderful book, The War of Words, by our colleague Molly Gupto-Manning, and it is a terrific book about publications during the war. And we give it to you with thanks for this evening. And I also want, before I leave, I do want to acknowledge Chief Judge Asim Rahman. Thank you for being here. And for everybody else, we will see you at our next breakfast. Thank you all for coming.